Hi there. I thought it might be useful to go over the primary court appearances that make up a basic family law case in the state of Maryland. And what I mean by court appearances is when the litigants and parties are required by the court to come to the courthouse and participate in some degree in their case. Now, not every case is going to have all of these, and some cases are going to have more than these, but these are the basic ones that most litigants are going to experience depending on how far their case gets. So taking them in chronological order, the first court appearance is generally the scheduling conference. And the scheduling conference is what it sounds like. It is an appearance at the courthouse, and it's an administrative appearance in which the parties and their attorneys tell the courthouse what resources that they may need or want to use for their case, and they schedule future appearances or services. So at your scheduling conference, you may schedule mediation in the future. You may schedule some of the other court appearances I'm going to talk about. You may tell the court that the case would be best if a best interest attorney was appointed and get that taken care of. So it is kind of the court lining up its resources and getting you on the court's calendar for future events. Now, generally, if it's needed, the next event is going to be what's called a Pendente Lite hearing, which we all call PL hearings, which is generally a half-a-day hearing in which the court's goal is to maintain, if necessary by court order, the status quo, whether it's for the schedule of the children or monthly financial support issues. The goal of the court is to keep things as close to as they were before the case was instituted until the parties come around and either resolve their case or have a final merits, either custody or divorce hearing. Next would be, in most cases again, either a settlement or a pretrial conference. And that's kind of the court's last stop, offering its own resources to check in on your case, to see if it can be resolved, to urge the litigants to resolve their case before scheduling a merits hearing. Now, your settlement conference or your pretrial conference, it's called different things in different jurisdictions, is most often handled by a retired judge that will, in most cases, hear from the attorneys, hear from the parties, and try to facilitate settlement discussions. And sometimes that's very useful because a retired judge might look at a party and say, well, if this case was in front of me, I might do this, which can be a very powerful thing for a litigant to hear and may get things moving towards a resolution. The other benefit of most pretrial conferences or settlement conferences is if the parties reach an agreement or walk into that event with an agreement. In most jurisdictions, you can get divorced, if that's the case, the type of case, you can get divorced that day. If you walk in and you have a consent order, if it's some sort of custody modification, your case can end on the spot because you have a retired judge that can sign an order for entry by the clerk. Also, most jurisdictions in Maryland will allow parties, if the timing of the case is right, to have more than one pretrial conference or settlement conference. Again, this is because the court system wants litigants to resolve their case by agreement and would much rather schedule your case for a pretrial conference or a settlement conference than set you in and have a 3-day family law case on a judge's docket, a contested case. So they'd much rather devote resources to resolving a case by agreement than by a contested trial. And then the last court appearance, that if no agreement is reached and the two parties are adamant that a finder of fact is going to hear all the evidence and make a decision, you have your contested trial dates, whether that's a divorce trial, whether it is some sort of custody or custody modification hearing. That is going to be the final stop as far as a court appearance. At the end of that, in most cases, again, this is all most cases, after you get that order or recommendation, whether it's a judge or a magistrate, that should hopefully end the case, but not always. Also, so those are like the big four, but there are other court appearances that may come up. One fairly common court appearance is a discovery hearing. Now, Parties don't often have to or aren't necessarily required to show up at a discovery hearing, but it is an issue that does come up in family law cases. Now, discovery hearing is necessary to resolve a dispute between the parties or the parties' attorneys as to information that is being sought by one party and is not being provided by the other, in terms of whether it's answering an interrogatory or some sort of document request. I would also say that in some family law cases, in the contested ones, you could end up with in a contempt hearing, which results from one party alleging that the other side of their case is not complying with an existing court order. If you get into other court appearances beyond that, you are definitely into a contested case for sure. And if that is the case, or you have any other questions about court appearances in family law cases, please do not hesitate to contact my office, Weinberg Schwartz, at 410-997-0203. If you have any questions for me, all of my social media accounts can be found in the information of this video below. There's my LinkedIn page, my Twitter account, my Instagram account. And as always, if you found this video helpful, please like it, please share it, please comment on it. I appreciate that very much. Talk to you all soon.